Right, well, let's make a start then. So say thank you for joining us on what's hopefully a sunny morning for yourself, as it is for me. And we appreciate you giving your time to come and hear all about today's subject. And today's subject is part of our series on how-tos. And today's topic is going to be how to deal with tenancies and tenancy changes. It's one of those areas where uh, one of the most frequent queries I think that our team gets on a regular basis. You'd think it would be fairly straightforward, but far too often the little intricacies of housing law, landlord and tenant regulations can be rather difficult to navigate. Certainly a lot more complicated than they should be, is the perspective that I have on it. Sadly, the situation we're in is because uh, housing law forms part of um, a broader subset of property law, and a lot of property law is pieced together from a whole host of different statutes which are designed to regulate different situations, but then combined with what we call the common law. And common law is non-statute based law. It's law that's essentially been invented by judges and courts and tribunals over the last few hundred years. And the way that that works in terms of case law precedent is that when a case is decided, which establishes a general principle of law, then that principle is potentially binding on other judges and other courts, as certainly if it's from what we call a court of record, which is the High Court, Court of Appeal, or Supreme Court. And it's binding unless and until it's overturned by a more senior court. And so we can be, or unless it's displaced by a statute that Parliament enacts. And so we can be stuck in a situation where we have a rule of law that was invented by somebody back in the 1800s in the Dickensian era, which might have made sense back then, doesn't necessarily make complete sense now in the modern society and modern economic situation, but we're stuck with it until somebody overturns it, or until Parliament passes some law to change it. And so that can be one of the more complicated areas to have to deal with. And it's why we end up with some very idiosyncratic principles, unfortunately. But there we are. And so we're going to try and not necessarily totally unpick all of these issues today, but we're going to have a look at some of the common problems come across. So just by way of an introduction, we're going to be giving an overview of legal implications of tenancy changes. I do have a training session which I deliver to clients, which is going into all of the finer details of it. That is not the session which I'm going to be delivering today. If I were, then we would still be here probably gone lunchtime, because there is so much to delve into, especially as quite often social housing landlords in particular can end up operating policies and procedures which don't fully align with the actual legal position. It's maybe what they've been doing as a business practice, just for efficiency or for practical reasons. But then we often end up having to unravel a few issues when we go through that. So we're just going to be looking at some of the overviews of the key issues that we could come across. We're going to have a quick look really at some of the issues which arise potentially from succession exchange and relationship breakdown. Going to give you some hints and tips of some key pitfalls to avoid, some of the implications, what can go wrong if you don't. And one of the overriding themes that we're going to be looking at as we weave our way through this is understanding the difference between what the law says and what your policy says. And having a bit of an understanding that sometimes you can influence the outcome, you can choose what the way forward is, and sometimes you just can't. Sometimes the law overrides what your policy says, and you just have to go with the legal position, irrespective of that. But then, in many cases, you may well have a choice, and you've got to make a decision as to how you proceed. So I'll touch on that on a few of those aspects. Before we do, just a couple of words about myself. My name is Lachlan McLean. I'm a partner in the Housing and Regeneration Litigation team. I've been at Forbes since 2005. I've been practicing in housing law and including social housing law since that time. So hopefully you'll be able to benefit from some of the experiences that we've come across during all of those many years, far too many years to be counting by now. Before we do proceed, I have to make you aware, obviously, that um, the materials are supplied as general illustrations of legal issues. Um, we have got Q&A, and feel free, by all means, to drop any questions in the text as we go, because this is for your benefit. If you've got any burning questions you want to raise, then very happy to try and deal with them. We actually had 3 questions raised of me before the session even started, so well done to you lot. But obviously, we won't be able to give specifically binding legal advice on any particular situation because we would necessarily need to see all of the facts of the case in order to be able to advise fully. But hopefully, we can start to um, deal with it. Just had a query from somebody just asking as well whether the slides be forwarded after the session, please. I'll check with our marketing team whether that's going to be possible, but I'm assuming that's the case, that there'll be certainly the one of the things actually I was going to mention as well is that the session is being recorded. So again, feel free to ask any questions. I'll try not to mention any names as we're going. Obviously, if you do raise any questions regarding any of your specific cases, please don't share any personal data regarding the parties involved. But yeah, please do. Oh yeah, so Catherine's just confirmed that slide and recording will be shared with attendees afterwards. So that's excellent news. Thanks very much, Catherine. And yeah, so please do feel to shout out any queries, and I'll do my best to give some thoughts on them. One other thing I've started adding in to these standard disclaimers is that because housing is a devolved matter, we are talking about social housing laws in England, unless we expressly state otherwise. Wales has its own regime, which has recently been enacted through the Renting Homes Wales Act, and obviously Scotland and Ireland have entirely separate legal systems anyway. So just apologies to anyone who's dialing in. If we've got anybody from the different parts of the UK, we are looking at England today, but hopefully you find it of use to yourselves. And at this point, what I'm going to do is I'm going to turn off my camera to try and enable us all to focus on the contents of what we're looking at today. So, looking initially, therefore, at some of the key changes, and I think one of the most common queries and one of the most common problem areas we actually come across is when a tenant passes away. Obviously, there's a lot of practical considerations to think about when a tenant dies. You've got to close down the rent account, you've got to sort out what's happening with all the personal belongings, you've got to notify the next of kin. If you know who they are, you might have to deal with coroners and the local authority benefits, police. Yeah, there's obviously lots of people who get involved when somebody sadly passes on. But one thing not to forget about amidst all of this is the tenancy itself. Now, hopefully many of you will be aware of this, but it's always something worth repeating. And that is that when somebody dies, it's not what happens to the tenancy. It's not like a mobile phone contract where the contract might terminate upon death. A tenancy is what we call an estate in land. It's not just a set of terms and conditions. It's not just permission to occupy property. A tenancy, actually, in English legal understanding, is a piece of real estate. Now, it might be a very precarious piece of real estate. It might be one that you can terminate relatively easily. It's not as anywhere near as secure or valuable as owning the freehold or owning a long lease, like 125-year or 999-year lease. But it is still a lease, even though we refer to it as a tenancy. It's maybe only from 1 week to the next, on a periodic basis. It might be for 12 months or for 5 years. But it's a legal estate in land, and it continues after death unless and until it is formally terminated. And it's really important that we remember that when we are dealing with the affairs of the deceased. And because the tenancy continues, it means that rent will continue to be arising on it. But we have to understand what actually can happen. And there are certain potential outcomes when a tenant dies. So the first question you have to ask yourself when a tenant passes away is, was it a joint tenancy? And the reason why this is really important is because of the way that um, legal estates and land are dealt with when a tenant dies. Um, when there is a joint tenancy, then what actually happens is that automatically the other joint tenant or tenants, because you can have up to four at one time, um, the other joint tenant automatically takes over as the surviving sole tenant. So that's called survivorship. Now, that might count as a succession for the purposes of the statutes, the Housing Act 1988, 1985, but this is a process that happens automatically. We'll come on to a case or example of this and how it can have really serious implications for the people involved. It's obviously very beneficial for the surviving joint tenant. It means that there's very little paperwork that needs to be dealt with. It's just a recognition of something which happens automatically by a process of law. But it can have unintended consequences in terms of if you have a tenant who is a joint tenant but who wasn't actually even living there, they can actually become the surviving sole tenant. So that's the first question you have to ask, is whether it's a joint tenancy or a sole tenancy. And then if it's a sole tenancy, then we have to consider whether there is any succession. And succession is what I would refer to as being a transfer of a tenancy, normally, upon the death of the original tenant. And these rights are quite quirky. There are different rules depending on whether it's an assured tenancy, and that includes assured holds, or if it's a secure tenancy in particular. And that's whether it's a secure tenancy, an old secure tenancy of a housing association, or a secure tenancy of a local authority. So succession rights are different. And also they are different depending on whether the tenancy was originally granted before or after the dates when the Localism Act 2011 came into force, which was the 1st of April 2012. Don't think necessarily that the Department of Housing really thought about the date, April Fools, but there we are, that's what it is. And so, yeah, the rules are different for before that, and the way it essentially used to work under the older style tenancies was that for assured tenants, if you would have an automatic right of statutory succession to a spouse, civil partner, or a long-term cohabiting partner, as long as they were living with the tenant at the time of death. And then beyond that, if you were an old style assured tenant, there was nothing else effectively in terms of automatic statutory succession. You might have various provisions of a tenancy agreement which said that there would be additional rights of succession to a family member, often especially if the housing association was a stock transfer landlord. But those rights never used to be automatically enforceable. They didn't take place automatically. Whereas the way that succession works under statute is that if the criteria are met, if you have a spouse, civil partner, or cohabiting partner, then the tenancy would automatically vest in the successor by what's called operation of law. So that means it's an automated process. There's no paperwork needed. It just happens. And I can give an example of a rather unusual situation where this occurred, very much contrary to clients' wishes and intentions, where there'd been a sole tenant and he had a lady living with him. Now, there was a dispute as to the nature of their relationship. Sadly, it was a violent and domestically abusive scenario where actually the lady was being abusive towards the man, the tenant. And it turned out that she was his ex-wife, and they'd split up and she'd moved back in. And there was a situation which caused a problem there. He died, and she argued, she asserted that she was actually still married to him. They'd never formally divorced. And this was therefore a dispute as to whether there had been an automatic succession or not. And the point I had to make to the client was, said, as much as the client felt really uncomfortable about this situation, it wasn't a case of what their policy said, it was a case of what the law said. And they had to get to the bottom of whether there was actually an ongoing legal relationship. So that's where we have to be really careful. Um, the old rules under secure tenancies used to be that you had automatic right of succession to a spouse or a civil partner, but not necessarily to a long-term cohabiting partner. And if there was no married or civil partnership relationship, then there was a secondary category of additional successors, which were called family members. Now, this included long-term cohabiting partners, also included children, parents, and nephews and nieces, and brothers and sisters, and so on. But they had to have been living with the deceased tenant for 12 months before the date of death. And that's what a lot of disputes have often turned on, is whether they could prove whether there'd been 12-month occupancy or not. What the government did back in the Localism Act 2011 was they tried to harmonise these two different sets of succession rules. So what they did was they basically created, they downgraded slightly the succession rights to secure tenants who took their tenancies from 1st of April 2012 onwards, so that the additional rights successions to family members were not automatically written into statute. But what they did is they also, in some ways, they upgraded the rights of succession potentially for assured tenants, because they said if your terms and conditions of tenancy from 1st of April 2012 onwards include an additional right of succession given contractually to a family member or any other person, then that was automatically binding. It took place by operation of law rather than having to go through the process of applying for succession and being granted a new tenancy. So it had a bit of an equalising effect. But the problem is that you have to look at when the tenancy actually started, because a lot of, although the great era of stock transfers was a long time ago now, there are still a lot of social housing tenants who were stock transfer tenants from before April 2012 who are still holding their housing association transferring tenancy rights. And so when I get these questions, the first thing I'll always ask to do is ask to see the original tenancy agreement with all the full terms and conditions, including the signature page. And I'll also ask to see copies of any additional versions of the tenancy which might have been signed at a later date. For example, if standard terms and conditions have been updated. This is absolutely crucial that you have to get which framework you're operating in before you go any further. And this has the bearing because, as I say, the succession rights can depend on whether they're statutory, contractual, or discretionary. If they're statutory, then it will take place automatically. There's nothing you can do about it. It just happens. If they're contractual, then it won't take place automatically, but you, as a housing association or as a local authority, you are going to be put in a position where you're likely to have to give effect to those rights in some way, shape, or form, whether that's by allowing the party to stay there until they can deal with the probate of the deceased tenant, or by re-granting them a fresh tenancy, or by allowing them to assign it from the names of the executors or the personal representatives into their names. Where the rights are discretionary, and I think this is where a lot of the drift of the industry goes in the minute, is allowing and reserving the housing association the right to make a discretionary decision based on the housing management priorities which are applying at that point in time. And where that happens, then you have got a really strong policy influence. So, as I say, in terms of statutory entitlements, your policy is not really going to make much difference. With the contractual rights, it could have an impact, depending on the approach you're going to take to give effect to that contractual entitlement. Where you've got a discretion, then your policy is going to come front and centre. So there's some of the really key considerations. So let me just have a look. We've had somebody ask the question of what happens if a tenant has passed away, but they've got no family, no next of kin. How do we legally end the tenancy? That's a really good question. Obviously, this is one of those areas I go into much more detail in my full version, the full fat version of this session. But I can just mention very briefly, it is important to still bring that tenancy to an end formally and officially. And the way you do that is you have to serve a notice to quit, because if there's nobody living there, it's no longer an assured actually, I'm assuming this is an assured tenancy. There are slightly subtly different rules around secure, but yeah, certainly for an assured tenancy, you have to terminate via notice to quit. That notice to quit has to be served on the personal representatives of the deceased, and you also have to lodge a copy of it with what's called the public trustee. And the public trustee is the kind of backup holder of all property in the country in the event that somebody dies without having executors appointed. If you've got executors, then you need to serve notice to quit on them. So it depends on whether they died leaving a will or without leaving a will. In terms of dealing with the tenant's possessions, that's again a slightly more fiddly issue, because you have to make sure that you if the estate is above a certain value, which is currently £500, then you have to declare it effectively to what's known as the Bonaventura division to see if they want to take ownership of it. Because if somebody dies without leaving any will, then technically, if they've got no next of kin, they've got nobody who's entitled to inherit their assets, then technically those assets belong to the government. They belong to the crown. So the Bonaventura division will want to know if you've got any substantial assets in the estate. Other than that, it can be a little bit complicated. Also had another question. Let's see if there's one I can deal with now, which is about the executors assigning to tenancy to someone. What I was meaning is that if somebody dies and leaves a will, they will have to appoint executors to actually manage the will, and those executors will hold the assets of the estate on trust for a period of time. Normally, what happens is they would then assign or assent the transfer of those assets to the beneficiaries. So that's what I was meaning in terms of if somebody's died, left a will, and the terms of your tenancy require you to allow the beneficiaries to take the benefit of that tenancy, then you have to give then you may have to give the executors an opportunity to do that. That's what I was referring to. Hope that clarifies the question that you have, and apologies for skipping over that detail. So let's look at an example of where what could possibly go wrong. Why is it important that we get these considerations correct? And this was an example of survivorship and the importance of understanding the impact of it. Very sad case, Solihull Metropolitan Borough Council in Hicken. And this concerned a local authority tenancy, which was originally granted in 1967 in joint names to Mr. and Mrs. Hicken. Now, the relationship broke down, Mr. Hicken left, but the joint tenancy was never ended. It was never updated or changed. What then happened was that Mrs. Hicken sadly died in August 2007, and her daughter, Elaine Hicken, had remained in occupation. She was still living there. And she claimed the right to succeed to the tenancy. She said, well, I'm a family member. I've been living here for over 12 months, so I'm entitled to succeed to this tenancy. What happened was Solihull Metropolitan Council served a notice to quit on Mr. Hicken as the surviving sole tenant, because he was no longer living there. So no matter where he was a sole tenant. And because he wasn't living there, it was no longer a secure tenancy, and the tenancy was terminated. The council then sought possession against Ms. Hicken because she didn't vacate, and it went through various appeals, and ultimately went to the United Kingdom Supreme Court, who ruled quite a surprisingly narrow majority, I have to say, 3-2, that the tenancy had vested in Mr. Hicken by survivorship. Therefore, it was no longer a secure tenancy. So the notice to quit, which was served on him, even though he was nowhere to be seen, that notice to quit was correct to terminate sole tenancy. And that was why it is important that everyone has to understand how survivorship works. Where this could also have an impact is if you look at things like the right to buy. Somebody's, for example, got an ex-council tenancy, and they've maybe had a relationship breakdown. The original tenant passes away. They've got an adult child who's been living with them. If the landlord then purports to recognise the surviving adult child as the tenant, it can get incredibly messy if that person thinks that they've succeeded to a tenancy, they think that they've qualified as a successor for the purposes of the right to buy or the preserved right to buy. And if it's not being managed correctly, you can end up in a situation where they're not actually eligible for the right to buy. Sometimes, enough to say, sadly, this often only comes out quite a long way down the line. We do a lot of right to buy transactions at Forbes, and I'll end up being roped in to advise on a tricky case where maybe they're not sure how much the discount should be. And I unpick all of the background to it. And I say, well, they're not actually entitled to the right to buy at all, because this joint tenancy was never ended. The tenant died. There was a sign, it survived in the name of the departed joint tenant. This person came along, they're not actually a qualifying successor at all, but they've been told that they are. They might have expended significant amounts of money doing the property up in anticipation of being able to exercise right to buy. And so that situation can become very problematic. So it's really important that these are managed correctly at the time, because people can end up having their hopes built up incorrectly and it causing problems many years later. Very good question just coming in the Q&A. So why is it classed as a succession if it was a joint tenancy and one of the tenants passes away, then the tenancy is placed in the sole name of the surviving tenant? Very good question, and it is a question of terminology. What it means is that when the Housing Acts 1985 and 88 look at the definition of what is a successor, there are certain circumstances when the tenant dies and the person who takes over is deemed to be a successor under certain circumstances. I think if there's been a succession under that statute, that's the obvious one, but there can be other circumstances, and one of them is expressly states in the statute that where there has been a joint tenancy and it has vested in the current or the recently deceased tenant by way of survivorship, then they are deemed to be a successor for the purposes of statute and any further successions or future successions, even if it was not technically a statutory succession properly so called. So that's just a question of statutory terminology. But you're right, it is an unusual sort of way of looking at it, and it does create confusion. That is for sure. That's why this training session is so well attended. So I'm just going to run through a few common problems that I come across or have come across over the years. The classic one is and a lot of housing clients' succession procedures that I've reviewed say that applications for succession must be made in writing. Well, it depends, because if it's a statutory succession, then they don't need to technically apply for it. It just happens automatically. Although, obviously, it helps if the next of kin let you know that they're living there so that you can process it, you can update your records. So you can be in a situation where someone is actually a successor. They have not necessarily formally applied for it, or maybe not within the timescales that you've asked them to. Let's say if you say they have to apply within 3 months or something like that. Maybe they've not formally applied for it. You then start possession proceedings because they're under occupying or causing problems. It can nonetheless still be used as a defence to the possession proceedings in those circumstances if their basis of defence is I am actually an assured tenant or a secure tenant because I took on this tenancy automatically via statutory succession. That can be raised as a defence potentially even at the last minute. So it's important to make sure it's being done correctly. And that's why if you enter any case like this of failed successors, we will always check the position to make sure that your understanding of the situation is correct. So where Does this matter? Well, in terms of your policy, your procedure, obviously, if it's not a statutory succession, if it's contractual or if it's discretionary, then that is going to be relevant because you're going to need to understand whether the person wants to take on the tenancy or not. Because if they are, you're going to have to grant them a fresh tenancy in all likelihood. Another thing I often spot is when clients' procedures say we may refuse succession where the property is underoccupied or unsuitable. Well, again, it depends. If it's statutory succession, then that occurs automatically without by operation of law. There may be certain grounds for possession, though, even with a statutory succession, certainly for certain tenure types. If the property has vested and it is underoccupied or if it was specifically adapted, then you might have a specific ground for possession depending on the legislation, or it might just be that you're in a position to activate a ground 9 possession on the basis of offering suitable alternative accommodation. So you do have to check the basis of it. Certainly where it's a contractual succession or discretionary succession, then under occupation, suitability, affordability are all going to be potentially, well, certainly for discretionary, are all going to be highly irrelevant considerations. So I think the issue is it depends on what you're dealing with. Another statement we often see is we say we may make succession conditional upon accepting liability for payment of the arrears. Well, this is quite an unusual quirk, and I think Shelter England have got a pretty decent summary of it on their website, and that is that where you have a statutory succession, well, apart from the fact we've already discussed quite a few times, it happens automatically, but in a very unusual twist of common law, if you've got a statutory succession, then the successor is not liable for rent arrears which accrued prior to the death. They're only liable for the rent going forwards, but not the arrears that accrued at the point of death. I think the reason for that, in terms of if there's a policy reason behind the judiciary's thinking on it, is because when statutory succession takes place automatically, but it means that actually the successor becomes the tenant, or instantly as soon as the original tenant breathes their last breath, the successor then takes over instantly. They don't even have to apply for it. Whereas when you inherit an estate under terms of a will or intestacy, you have a degree of the ability to disclaim your inheritance. You can say, well, actually, I don't want this inheritance because it's actually more onerous. Maybe it's saddled with a lot of debt. So you can refuse it. You can't refuse statutory succession. It takes place automatically. So as much as the landlord might not want it, the next of kin might not want it either, especially if it comes with, say, congratulations, you have statutorily succeeded to this tenancy. You are now the new assured or secured tenant of this property. By the way, it's £10,000 worth of rent arrears. Could you pay it within 14 days? I don't think that would go down too well. So the law says actually up until the point, if you have a statutory succession, up until the point of death, the arrears are owed by the estate of the deceased. So they can only be paid off by the assets that were owned by the deceased tenant before they died. It's not going to be the responsibility of the executors or the personal representatives to pay off all of those debts out of their own personal funds. They can only pay it out of what they can get from the estate from selling the belongings or cashing in any insurance policies. And that's all arises from a case from 1929 called Tickner and Clifton. Another one, common misunderstanding we see is I see a lot of policies and procedures for housing associations which say there is no right of succession to starter tenants. That is simply wrong. Starter tenants, in terms of the basic succession rights to a spouse, civil partner, or long-term cohabiting partner, they get those from day one. As an assured shorthold tenant, they have the exact same rights as what we might refer to as a fully assured tenant. There may be additional succession rights, which might be contractual or discretionary. Now, that is where it is going to come into play, because you may have a policy or procedure where you say, well, we don't allow succession to next of kin, non-married or non-long-term partner family members for starter tenants, but we do once they've completed the probationary period. Well, that's separate. That's a complete consideration. Another one I see quite frequently, especially at the minute, so we put the next of kin on the means profit account from the date of death. I have to say, sadly, whichever way you look at it, that's not correct. Because if they're a statutory successor, they don't need a means profit account because they're liable for the rent straight away. Now, I appreciate one of the difficulties you may have actually in the short run, and I should probably, fairness to my clients out here, is that it might be that you don't know whether they're a statutory successor or not. The objective legal scenario is one thing, but actually proving it can be something else. Especially if you don't know if they were a long-term partner or not, or just a friend or a passing acquaintance. But from a objective legal perspective, you might have to maybe put them on what might look like a means profit account or sub account as a short-term measure. But bear in mind, from a legal perspective, the statutory successor is liable for the rent immediately upon death. If they're a contractual put my teeth back in, a discretionary successor, then you're going to have to re-grant them a fresh tenancy in all likelihood. And so in which case they're not going to owe the rent until after the original tenancy is formally ended. Up until that point, whilst that tenancy is continuing, then the arrears or the rent that's charging up continues to be in the name of the estate, not in the name of the anyone who happens to be living there at the time. Another one we get is you'll be required to sign our standard tenancy agreement. Well, obviously that may be very well be helpful to make sure that the terms and conditions are up to date. But again, statutory succession happens automatically. There's no need to sign a new standard tenancy agreement. They can refuse to do so if they wish. Obviously, it is often beneficial to the parties to update the terms and conditions. And again, in terms of the sorry, actually, I apologize. I've put that line in twice. That should have been from a previous point. So we can't, but it where it may be relevant is where you've got a contractual or discretionary succession. You will have to sign a new standard tenancy agreement in order to give effect to the entitlement. So that's very confusing. I appreciate this is problematic. That's where I tend to make sure that your procedure documents have to be really clear, so that anyone who's trying to navigate it, especially if they're new to the business, understands that if it's option A, you do this. If it's option B, you do something rather different. And it's just important to try and get it right, because if you get it wrong, it's confusing. I've seen cases where someone thought there was a statutory succession, but it wasn't. No terms and conditions of tenancy were re-signed. The original tenancy was never ended, and it creates all sorts of factual and legal uncertainties. So that is a bit of an overview of succession, and that is one of the most common problems that we come across. In terms of relationship changes, that's possibly the next most common difficulty. And one of the queries that we had actually before was how do you remove a joint tenant from a tenancy when the tenant has committed domestic abuse or antisocial behaviour? I think it's really important to understand that a joint tenant cannot be simply added or removed. Oh, apologies, that was our fire alarm going off. So everyone who was drifting off to sleep is now wide awake. So a joint tenant cannot be simply added or removed without at least some form of written agreement from all the parties. So that's include the landlord, any existing tenants, and anyone who's going to become an additional tenant, or if you're going to remove someone, they have to agree to it in writing. And that is a legal requirement of Section 53 of the Law of Property Act 1925. It just is. There are certain other workarounds potentially in certain circumstances, but you need to have some degree of evidence in writing realistically. It used to be a legal requirement that it also had to be by means of a deed of assignment. The rules on that have been slightly relaxed in relation to social housing tenancies, and that again was a Localism Act thing. So it doesn't have to be by a deed now if it's a social housing tenancy, but it still has to be in writing. And I would say a deed is much better in terms of the way that it works. Um, so how do you remove a joint tenant from a tenancy? We'll talk as well in a moment about the impact of having to get written agreement. Um, but yeah, I used to see very frequently, I'd be passed a copy of a tenancy agreement where a housing officer would have just literally drawn a line through a tenant's name with a ruler. Back in the days when we did everything on paper, they would literally get a ruler and a pen and cross out the name and initial it themselves on the basis purely of an email or a telephone call from the person who had moved out. That would not be effective to remove that joint tenant from the tenancy in and of itself. And again, as we saw with Solihull and Hickin, that can cause much bigger problems further down the line if it's not processed properly. Similarly, you can't just add them on by means of a verbal request or an email request. There has to be some clear written agreement to change the tenancy, to do what's called an assignment of that tenancy, which is the transfer into or out of joint names. One of the other questions we got asked by delegate in advance of the session today was, do you support the policy of refusing all sold to joint tenancy requests? I think it's certainly helpful to have limitations on the circumstances when you would approve sold to joint tenancy requests. I think you need to be very clear in your policy as to when you will or won't allow it. I don't think it would be I think it would be very difficult to sustain a blanket policy of refusing all requests in all circumstances for a number of reasons. One, because it's likely to have some kind of discriminatory effect somewhere under the Equality Act 2010. If nothing else, from a point of view of human rights law and public law, that may well amount to fettering your discretion or acting irrationally or unreasonably. So I think you can have it as a starting point, but I think you need to have the ability to make exceptions where it's justified. Because as much as you can have that as your general policy, you'll often life throws at you circumstances where you find the exception to the rule where it causes more problems than it solves. Somebody's just asked a question as well. If a joint tenant has left the household is no longer contactable to give their consent to be removed, can they be removed? I'll answer this in just a moment because that's actually on the next slide rather conveniently. I have also seen the other query about succession and mutual exchange. I'll come on to that. We're going to look at mutual exchanges next. So in terms of changes to tenancies, we've got joint to sole, sole to joint. For secure tenancies, just bear in mind as well, the options for joint to sole and sole to joint are very limited because assignments of secure tenancies are restricted by statute under the Housing Act 1985. You have to be able to shoehorn yourself into one of those circumstances. Oops, sorry, that's clicked on. I wasn't meant to do that. If you can't shoehorn yourself into those circumstances, you may have to stop and restart the tenancy effectively by notice to quit or by a surrender and regrant. So not really ideal, but sometimes that's all you can do. The Housing Act 88 has got a lot more flexibility. You can effect an assignment with the landlord's consent. So if landlord consents to it, then you're fine. Talking about family court orders, and I think, this will also have some degree of relevance to where you got a departed joint tenant. Bear in mind when you're dealing with breakdowns of relationship where there might have been some abuse or violence involved, be really careful about looking at what the statute was under family law, which gave effect to a change of tenancy status. So, for example, if you've got a family court who said that there should be an assignment or a transfer from the parties' joint names into one of the parties' sole names, or from one party to the other, either by means of divorce or civil partnership dissolution, or because of the protection of the children. Um, because of domestic violence or abuse, check which piece of legislation it was made under. If it was under the Matrimonial Causes Act or the Civil Partnerships Act or the Children Act, most likely you'll probably need to actually have a written agreement to give effect to it. And I fully understand that in relationship breakdowns which have gone legal, the parties might be unable or unwilling to work together for various reasons. So the mere fact the family court has ordered it doesn't mean it necessarily automatically happens. In comparison, if you compare Schedule 7 of the Family Law Act 1996, this specifically anticipates a situation where, for example, if there's been abuse or violence, it stands to reason you're not likely to get cooperation from the abusive or violent ex-partner. And so the statute provides for a power for the family court to order and automatically give effect to the transfer of tenancy from one party to the other, and that overrides the usual limitations on needing to have written agreements to the transfer of the tenancy. Other than that, as I say, whether that's due to relationship breakdown or because one party is now absent, alternatives may include having to stop the tenancy via notice to quit and re-grant it afresh, or sometimes you can do what's called a surrender and re-grant. But surrender and re-grant is going to be a bit trickier because that needs the agreement of all joint tenants. So if you cannot get the agreement of the joint tenant and the court order isn't going to solve it, then your only option may be for one of the two joint tenants to serve a 4-week notice to quit, terminate the tenancy, and re-grant it in their sole name. But then that's going to be down to your own discretion or policy management as a social landlord or a local housing authority. So that, and they are difficult circumstances, and we're always happy to give advice when something like that happens. Just going to check the Q&A. So that question's been answered, and that now we come on to mutual exchange and the implications of that. So, as I say, in terms of mutual exchange, what is a mutual exchange anyway? In any case, well, mutual exchange is actually a simultaneous assignment of tenancies. There are processes actually under the Localism Act 2011 for dealing with transfer of tenancies where you've got one periodic tenant and one fixed term tenant. Those circumstances when you're going to need to do that are becoming increasingly limited because fixed term tenancies are hardly used now. It's useful to be aware of that, but I don't really go into that in lots of detail anymore because it happens so rarely. Mutual exchange is very frequent and a very common way of allowing people to downsize or upsize or move from one part of the town or the country to another. The first question you have to look at is it a joint tenancy? And not are they joint occupiers, but have you got on your hands what was originally granted as a joint tenancy, and one of the parties might have moved out and is no longer able to sign the mutual exchange deed. You've got to check that first, because if that's the case, then you can't assign a tenancy if you don't have the consent of all the current joint tenants. You just can't. So you're going to have to resolve that first through one of the means that we talked about previously before you can actually make the mutual exchange happen. Again, the rights of mutual exchange, they're going to vary according to whether they are an assured tenant or a secure tenant. For secure tenants, you've got very specific statutory grounds of refusal, and you have to be able to identify one of those grounds. And if you can't, then you have to consent to it, albeit that if they're in rent arrears at the time, you can make the consent conditional upon them paying off the arrears. And there are also very specific statutory timeframes for work to, I think it's 42 days. And if you don't respond within that timeframe, then you are deemed to have consented. So those ones are really time sensitive. If you're an assured tenant, it's a lot more flexible. Usually, there are no statutory grounds of refusal for mutual exchange, but there may be some specific grounds of refusal written into the tenancy agreement. And if those are written in black and white, then the landlord has to respect those. And in terms of timescales, again, there's no statutory timescale for complying with a mutual exchange for an assured tenant. But again, the tenancy agreement might well specify something. And if it does, then that will obviously come into play. So when you're looking at requests for mutual exchange, your potential grounds for refusal, your starting point always has to be looking at the basis for refusal. Is it statutory? Is it, have you got your hands tied by the terms and conditions of the contract, or have you got a complete discretion? And this is where your policy can really come in. Your statutory rights are obviously going to override the terms of your policy. But if you've got a discretion, then you need to have a very good look at that and make sure that your policy on it is really clear. So in terms of mutual exchange, and the question was asked, if two parties complete a mutual exchange, do they get new succession rights even if there's been a statutory succession? I'm afraid I'm going to have to get back to you on that one, because I don't know the answer off the top of my head, and I don't think that the delegates would really thank me if I was to go off and have a look at it. But if we can keep a note of that query, then I'll try my best to find out the answer and let you know after this webinar is concluded. So you've managed to catch me out on that one. So congratulations. Not many people manage that. You've managed it on this occasion. Just had a query rating back to the issue, is actually going back to the issue of assignment. It says, does an occupation order mean that a landlord has to transfer a tenancy into a sole tenant victim's name, or is it only a transfer of tenancy that allows this to happen? I would say the latter. An occupation order is just saying someone has to get out and they have to let the applicant in. That does not in and of itself transfer the who is the tenant of that tenancy. So, and especially because an occupation order can be set aside, it can be varied, it can be discharged. It may be granted for a period of time. It might have been granted without having heard the full facts from the partner who's been alleged to be perpetrating the abuse or violence. And do they have to transfer the tenancy into the sole tenant's name? In and of itself, through the occupation order, not necessarily. That's not a court order telling you to do that. But I think you'd need to look at the circumstances of the case to see what you think is the right thing to do. You may need to await the outcome of the family proceedings before you make a final decision. But that's down to yourselves as to apply your common sense and say, well, do we believe this person? Do we have enough facts to be able to make a decision on it? Is it a clear-cut case? So that's that hopefully answers that particular query. I think we've got somebody's raised their hand, possibly. I thought I saw as well. So maybe if there's something that Catherine, maybe you could type in any query that you might have at this stage. Last point that we're going to move on to is a slightly quirky consideration, which was actually pointed out to me by a colleague not that long ago, which is a bit of idiosyncrasy, but when you have a change of tenancy status, whether it's through a contractual discretionary succession or some kind of change of tenancy status, mustn't forget compliance considerations on the right to rent. You may be aware that tenancies which are granted under statutory allocation, so that's through like a choice-based letting scheme, or through homelessness provision, so where local authority makes a nomination under homelessness laws, then those tenancies are exempt from carrying out your right to rent checks when you initially rent them out, because the local authority should be responsible for making sure that any eligibility criteria are met in accordance with the statute. Similarly, legally mandated transfers, so for example, if you've got an automatic vesting of a tenancy via survivorship or statutory succession and so on, they will similarly be exempt because you can't really do a right to rent check before somebody dies unless you're incredibly well organised. But bear in mind that regrants of tenancies and assignments of tenancies, including from joint to sole, may or sole to joint, may not be exempt from right to rent checks. And this is through a little known piece of legislation, which is the Immigration Residential Accommodation Prescribed Cases Order 2014. And this is a small piece of legislation which supplements the Immigration Acts and specifies when certain tenancy changes will or won't be deemed to be a new letting for the purposes of carrying out a right to rent check. So do make sure that your policy procedure factors that in, either through the succession procedure or through your tenancy sign up checklist or whatever it is that you do to make sure that you cover all your bases. So that concludes the formal part of the presentation, and we're just in time, 57 minutes in. So I'm quite pleased that we've managed to get there. I've just seen somebody raise their hand. I don't know if you want to just trying to have a look at the it seems to have gone back down again. I was just looking at the chat. So it says, oh, so it's okay. No problem if you don't mean to raise your hand, no problem at all. If anyone has any other questions, then feel free to drop them in the Q&A for in the next couple of minutes. We can allow a few minutes longer. We can also, I'll just pass on to, here's my contact details, which obviously you'll get the slides and the recording out as part of the follow-up to all of this. So let me just have a look at right. Oh, a very good question. Somebody just come and says, who can give notice? So I think when there's a lack of capacity, well, not the person who lacks capacity. Yeah, if you're looking at somebody terminating a tenancy and there's a mental capacity issue, slightly different from what we've looked at so far, but very good question. It would have to be someone who is authorised under relevant legal requirements. So that would be normally a donee of lasting power of attorney, of the right kind of power of attorney as well. It has to be for property and financial affairs. Or if you don't have a power of attorney in place, which was entered into before the person lost capacity, or if they never had capacity, then it has to be in pursuant to an order of the Court of Protection, either by a deputy who's been formally appointed, or you can apply for Court of Protection orders, which give a limited authority to an applicant to be empowered to end a tenancy if it's in the best interests of the tenant who lacks capacity. But yeah, you can't just accept a notice to quit from a social worker or next of kin, as it were. It is important that it's done properly. That said, if you've got someone who lacks capacity and they've moved out, then don't wait for them to terminate the tenancy. You can terminate it yourself. If there's nobody left who's the tenant, who's on the tenancy agreement, then if they've lost security to terminate, you can terminate that through notice to quit. I think that's important for people to understand. I've seen cases in the past where someone was moved into a nursing home and the property was left sitting empty for months and months on end because they'd never received a termination notice for anyone. If the tenant has moved out, get that tenancy terminated and a notice to quit. Make sure obviously there's nobody living there, and then re-let it at that point. So that should hopefully answer that query. Does discretion have to be shown? Another question. Before refusing a succession, shown to be considered before refusing succession. I would say that if you've got a discretion as to whether to allow somebody to take on a tenancy or to continue residing in the property or to be granted a fresh tenancy, then part 3 of the protocol, pre-action protocol for repossession of properties by social housing landlords, is going to require you to have demonstrated that you have taken into consideration the personal circumstances of anyone occupying the property before you then go to start possession proceedings, and you have to be able to demonstrate that you have taken those factors into consideration or at least requested them. So yeah, you're going to have to do that at some point, realistically. We've got a few more Q&As coming in. Please do keep them coming in. Obviously, for anyone who's now needing to rush off now that it's 11 o'clock, don't feel bad. Yeah, if you need to go, then please do. It's been very good to have you. We're going to carry on answering a few more of these questions as we go, though. But thanks to anyone who's having to make their way on by now. So I've answered that question. I've had another question come in which says, can I just check we can serve an NTQ on a tenant who's moved into a nursing home in last capacity? As I said, yeah, as I just mentioned just now, yes, you can. That's my view. My view is that even though they lack capacity, a notice to quit is what is a unilateral act by the landlord. You are giving notice to them. They don't have to necessarily be able to comprehend it. That's my personal view on the matter. And I do think it's the most effective way to terminate a tenancy in those circumstances. So that's the question answered. Just going to now check the chat, make sure if there's any queries that have been asked. Lots of lovely compliments, so thank you very much for all of those. Really appreciated it. Yeah, the mutual exchange question stumped you. Please can you share the response with all attendees afterwards? I will do my best to ask Catherine to pass that on the answer to as part of our follow-up information. I've got a question here said, I have a family who live in a 4-bed. The main tenant's gone to a care home. Son who is independent from the home is the power of attorney. He's paid off the arrears, consents to sign tenancy to his sister who lived there for years. We have concern around the capacity of the tenant's daughter to maintain tenancy. She's alcohol dependent, has 2 children. You know, oh gosh, this sounds very complicated indeed. Do you have powers to refuse assignment? Very good question. I am so sorry, but I'm not going to be able to answer that just on the basis of even on the basis of this information provided. That sounds like a very, very tricky situation that you've got there, and we'd be very happy to provide some formal advice on that with sight of all of the relevant information. But I think that one's get a little bit beyond giving a generic advice, I'm afraid. But I'm very sorry to hear about that scenario, and I do hope that you'll be able to find a way forward on that very soon. Yes, I look forward to receiving your email. One other thing to mention to people before we disappear is a quick shout out to my colleague Shirley Farragher, who's going to be doing the next how-to session on the 16th of October, which is on how to liaise effectively with partner agencies. So make sure you get books onto that one, and especially if you've enjoyed this. I did comment to marketing team. I think if we change the title of that slightly to how to liaise effectively with partners, we get a very different series of people looking for some advice on issues to do with relationships. But yeah, I think dealing with partner agencies is such a key thing these days to make sure you're dealing with it. Getting all the right people around the table and the right information to be able to manage your tenancies and situations as effectively as possible. So yeah, we're really looking forward to that session that Shirley is going to be running. A couple more questions still coming in. I think I'll do this one last one, and then I think I'm going to have to draw things to an end. So if we've got hang on, let me just check. Oh, there are a few other formal Q&As popping in. Okay, right. I'll answer the ones that are up here now, and then I'll draw things out. We've got one query said, if a young female currently has temporary parental responsibility for their siblings, can we grant her a tenancy once her stepdad tenancy is ended? He's in prison. Well, I don't think I've got enough information around the background facts to that to understand the full circumstances of what's going on. Again, it sounds like a rather complicated scenario, and it depends on how her stepfather's tenancy is due to end. Like the mere fact that he's in prison is not going to bring the tenancy to an end. You have to think about some particular considerations around whether you've got grounds to end that tenancy and on what basis. So I think it's difficult for me to say in general terms what you do in those circumstances, but you Oh, so possession order has been granted to end its tenancy. Well, okay, you've got the possession order. Well, bear in mind you're going to have to then execute that possession order as well. So you're going to have to make sure that the bailiffs turn up and they change the locks, even if you then let the family back in immediately afterwards under a fresh tenancy agreement. Um, it would seem, well, if you terminated the tenancy, then you can re-let the property as long as you're complying with any arrangements that you have with any sort of, nominations agreements or choice-based lettings requirements. Then it's then down to you to decide who you re-let that property to. Um, the question is when you say young females, it depends on whether they're 18 or over, because obviously you want to be careful managing equitable tenancies as well. So sounds like yes, it's over 18. Well, yeah, I think it would be. I can't off the top of my head, I can't see any reasons why, but as I say, that's the general observation. That they'd have to, in order to give formal legal advice, we'd have to see the full papers. But hopefully, that gives you a bit of a steer in the right direction. But I would mention the essay just because you've got a possession order, just bear in mind that under the terms of the Housing Act 1988 in particular, um, the possession order itself doesn't end the tenancy. Just bear that in mind. It says that unless the tenant ends the tenancy, you as the landlord, not only have you got to get a possession order, but you've also then got to actually formally execute that order through a warrant of possession by the bailiffs. But no, good question. A couple more just coming in on the Q&A. Can you accept an NT, I'm presuming that's meant to say NTQ rather than NTV, for a joint tenancy following death when the surviving partner has not been living there for a number of years, having separated? Yeah, if you've got a joint tenancy and the surviving sole tenant hasn't been living there, then yeah, they can end the tenancy themselves if they want to. It's their tenancy to do with as they wish, but as long as they also give the correct notice period. So that's answered. A number of ones left in the property, some of high value. Well, in terms of personal belongings, well, that's a separate issue. I think you have to obviously bear in mind whether there might be any beneficiaries entitled to take the benefits of those assets under the estate. They can get a bit complicated, so I'm not going to go into delve into the details of that now. But yeah, ending the tenancy is the easier of the two issues. Yeah, if you're a sole tenant, you can terminate the tenancy anytime you want. If it's a periodic tenancy, so that's no difficulty with that. Very well. So there we go. I think that's covered everything. We've been a wonderful audience. Thank you so much. Brilliant questions. Really appreciated. Lots of really good engagement. So it's been, I'll just minimize all my windows so I can even see my own screen. And I'll quickly pop my video back on again for a few moments. Thank you very much. Hope you have a wonderful day and wonderful week ahead. And yeah, we'll look forward to catching up with various of you in due course. Take care then. Bye bye.